Swayam Prabha. Digital India. Educated India.
Hello friends, this is lecture number 10, Protection of Women from Immoral Traffic, under the course of Law relating to Women and Children. In the present lecture, I will talk about the immoral traffic and why there is the need to protect the women from this immoral traffic. Human trafficking is very grave and serious problem all over the world. We know that every person is entitled to right to human dignity, and this is the greatest attribute of the life, that a person has the dignity or right to live with human dignity. But the trafficking in human being, it detaches the dignity from the personality, from the life of the persons, and particularly from the life of the woman. And therefore, it is important to protect the women from such immoral trafficking. It is not also in accordance with the ethics, morals, or the societal standards that the trafficking is done. What is the international law? What is the constitutional mandate in India? And what are the legal provisions or the initiatives on the part of the legislature? This is important to discuss these international and national provisions or legal initiatives for protection of women from immoral traffic, so that we can understand that whether the legal regime is sufficiently capable of, it is adequate to protect the women from immoral traffic, and what initiatives have been taken. It will also help us in understanding that what more is needed for protecting the women from immoral trafficking. Human life possesses the attribute to live with dignity, freedom and liberty. As I already told you, that human trafficking detaches the freedom and dignity from the person's life. Human trafficking is done in a singular act and also in the form an organized crime. We know that this human trafficking has become an organized crime also. It is done in two ways. It is done in a singular act when the trafficking is done to a person, individual person is trafficked, then this is the individual trafficking, or this is the trafficking which is done in singular act. But this human trafficking is also being done as an organized crime. That is why the nations not only penalize human trafficking, but also accommodate the international intervention to completely eradicate human trafficking. It is not possible only by initiating on the part of the nations only, or it is not possible for the nations to eradicate the human trafficking only by applying the legal standards of their countries or the legal initiatives taken on the part of particular countries. The international interventions are also significant to eradicate or to protect the women from immoral trafficking, because it is being done in the form of an organized crime at international level. Now, the borders are not matter in relation to the crime of organized crime of human trafficking. This is being done by crossing the borders of the countries and nations. Therefore, interventions or the international law becomes important. Whenever any such crime is organized, whenever any such organized crime is done in the country by the residents or the citizens of any other country, then the national legal provisions or national legal initiatives or the law of a country becomes ineffective in relation to that person who is committing the crime of immoral trafficking sitting in another country, and therefore the international law, the assistance of international law or the application of international law becomes must, and therefore, it is significant for any nation, for any country to accommodate or to take the assistance or the help or to take to give effect to the international provisions or the provisions of international law in their national legislations, so that such kind of the women can be protected against such kind of crimes which are being committed by the nationals or the citizens of any other country. Every year, July 30 is celebrated by United Nations as World Day Against Trafficking in Persons. We can understand the importance or the significance of this crime against the women. United Nations took the cognizance of this crime and it decided to celebrate 30th July as the World Day Against Trafficking in Persons, so that an awareness may be created or the people may be made aware about the human trafficking and particularly the trafficking against the women. If we see the international initiatives or if we see the international mandate given by the international law, there are certain conventions, there are certain international agreements, there are certain international law to protect the women from such human trafficking, to protect the persons from the trafficking and also the women from immoral trafficking. First, the Convention on the Rights of the Children, 1989. CRC, this convention CRC, in the name of CRC, Convention on the Rights of the Children, it was agreed to in 1989 by the international community. Article 33 provides that state parties shall take appropriate action, including legislative, administrative, social and educational steps to protect children from being used in production and trafficking of narcotic drugs and psychotropic substances. This is very important provision of CRC in relation to human trafficking. You may have the confusion or doubt that Article 33 of this convention of CRC provides that state parties shall take appropriate action to protect children from being used in production and trafficking of narcotic drugs and psychotropic substances. The state parties are to take legislative initiatives, administrative initiatives, social initiatives, educational initiatives, meaning thereby the state parties or the members to this convention, they are to enact the laws, they are to take the administrative measures, they are to take social initiatives or social steps or social measures like the awareness in the society about the human trafficking or about the involvement of the children in the production and trafficking of narcotic drugs. Educational steps are also needed to be taken by the state parties in this regard. Then one doubt or confusion may arise in our minds that Article 33 is not directly related to the human trafficking or the immoral trafficking of women. Then why it is relevant to protect the women from the human trafficking or from the immoral trafficking? Friends, see, this Article 33 directs the state parties to take legislative, administrative, social and educational initiatives to protect the children from being used in production and trafficking of narcotic drugs and psychotropic substances. If we see the organized crime of human trafficking or the organized crime of trafficking of the women, then the production of narcotics or narcotic drugs and trafficking or transportation of these narcotic drugs or psychotropic substances, this becomes the base or the foundation for committing this crime. When the narcotic drugs or psychotropic substances, they direct hit the mental condition of the children, and when the children are used, it is very easy for such persons who are involved in such crimes to use the children, because the police, the administration of different countries, they consider the children as innocent and they cannot doubt on the children, and they can very easily transport these narcotic drugs or the psychotropic substances from one place to another place by the assistance or the help of the children. They use the children for this purpose or for committing such kind of crime. And when these narcotic drugs or psychotropic substances are transported from one place to another place, and when these are used by the children, then these substances hit directly on the mental condition or psychological condition of the persons. It becomes easy for the criminals to use the children first for in the production and trafficking of narcotic drugs and psychotropic substances, and by using these psychotropic substances, narcotic drugs, they can change the mental state of the children and women, and they can commit this crime of human trafficking or the trafficking against the women. And therefore, if we curb or we address this problem of production of narcotic drugs and the transporting and trafficking of such psychotropic substances, then certainly it will assist or it will help in eradicating the problem of human trafficking, the problem of trafficking, immoral trafficking against the women or immoral trafficking of women. Then Article 34 of CRC. This Article 34 CRC imposes the duty on state parties to take necessary steps to protect children from all forms of sexual exploitation and abuse by inducement, coercion, prostitution and exploitation via pornographic performances. Now, see the connection in these the production of narcotic drugs and psychotropic substances. First, these narcotic drugs are produced, these psychotropic substances are transported, they are used in the children and women, and then when their mental status or psychological conditions change, then they use the children and girls, they use the women for the purpose of prostitution, for the purpose of their sexual exploitation. And therefore, Article 34 imposes the duty on the state parties to take necessary steps to protect children from all forms of sexual exploitation, including the abuse, sexual abuse. This sexual abuse may be by way of inducement, by way of coercion, by way of prostitution and exploitation via pornographic performances. So, in any way, if such sexual abuse or sexual exploitation is made, it is certainly contrary to the dignity of the person or dignity of the life of the person, and it is not possible for that person or woman to live with human dignity, and therefore, Article 34 imposes this duty on the state parties to deal with such problem of sexual exploitation. Then the optional protocol to the Convention on the Rights of Child on the sale of children, child prostitution, child pornography. I told you that this trafficking of women, the crime of the trafficking of women, it is done in the form of singular action or in the form of organized crime. We can understand how the trafficking, the crime of trafficking is done as the organized crime if we refer to the instance of prostitution. Prostitution is the form of organized crime of trafficking of women. First, the women are trafficked for immoral purposes, and then such organized crime is committed in the form of prostitution, and child pornography has also become today the crime, organized crime at international level. And therefore, the optional protocol to the Convention on the Rights of Child, optional protocol to CRC was adopted. This optional protocol is on the sale of children, child prostitution and child pornography. Often we see the instances of the sale of children, the theft of children. The theft and sale of children, particularly the theft and sale of girl children or girl child, it is done for the prostitution or for the bonded labor, and mostly the sale of the girl child is made for the purpose of prostitution and for the purpose of child pornography, and these two have been established as an organized crime, and therefore it becomes important, it becomes significant to deal with this problem to protect the women from immoral trafficking. There is very close connection between the theft of the children, particularly the girl child, and then the sale of those children, then the child prostitution. This is a series of events. All these events are connected to each other, and during these all the events an organized crime in the form of human trafficking or trafficking against women is made. The purpose of the trafficking of the women is to use those girls or women for the purpose of prostitution or for the purpose of pornography, and therefore this optional protocol was adopted by the international community to protect the children from the theft, from the sale, from their use in the prostitution or their use for the child pornography. This protocol was adopted in the year of 2000. Article 1 of this protocol says that the state parties shall prohibit the sale of children, child prostitution and child pornography. The state parties shall, this is the, it seems that though we know that international law is not mandatory for the nations, it does not have the mandatory nature, and the state parties are not bound to apply the international law in their nations. This is the discretion of the state parties, this is the wish of the state parties. But if we see the phraseology being used in this article, that is article 1 of this protocol, it seems that this is the mandatory direction of international community, of international law, that state parties shall prohibit the sale of children, child prostitution and child pornography. If we want to effectively deal with the problem of trafficking of women, if we want to protect the women from human trafficking, then certainly it is essential, or it becomes the condition precedent, that first we should effectively deal with the theft of the children, with the sale of the children, with the child crime of child prostitution, and then the crime of child pornography. Because the trafficking of women is made for the same purpose. So, if we effectively deal with the sale, the theft of children and child prostitution, child pornography, then certainly we can protect the women from human trafficking or from immoral trafficking. Article 3 to this protocol makes the state parties duty bound to impose penal liability for offering, delivering or accepting a child for sexual exploitation, transfer of organs, engagement of child in forced labor, prostitution and pornography. I think that this article 3 of optional protocol is very important provision, because this article 3 includes all those instances, all those crimes, all those offences which are responsible for, or for which, or for the purpose of committing which crimes or which offences the trafficking of women is being committed, is being done. And therefore, article 3 of this protocol imposes the duty on the state parties to impose penal liability for offering, for delivering or accepting a child for sexual exploitation. So, the national parties or state parties are duty bound to impose penal liability for what? For offering the child for sexual exploitation, for delivering a child for sexual exploitation, for accepting a child for sexual exploitation, for offering, delivering or expecting a child for transfer of organs. This is also one crime which is being committed in the area of medical science. The theft is made or the children are sold for the purpose of the transfer of organs. So, this has also been established as an organized crime, and in we see the instances, we see the various hospitals or various doctors, they are involved in this organized crime of the sale of organs or the transfer of organs. So, it is because the organs are very costly or they are needed for a person, then this via media has been evolved, that to have the organs of the children at lower cost, that the human trafficking or the trafficking of children for the purpose of the transfer of organ. And therefore, it is the duty of state parties to make the penal provisions for the purpose of dealing with the situations like the if anybody accepts, if anybody offers, or if anybody deliver a child for the purpose of sexual exploitation, for the purpose of transfer of organs, for the purpose of engagement of the child in the child labor. It is also one very big problem which we discussed in earlier lectures. So, child, if any person offers any child, if any person delivers any child, if any person accepts any child for the purpose of sexual exploitation, for the purpose of the transfer of organs, for the purpose of forced labor, for the purpose of prostitution, then state parties are obliged under Article 3 of this protocol to penalize such persons. Then one more initiative on the part of international community or in the area of international law is the Convention on Elimination of All Forms of Discrimination Against Women 1979. This is called as CEDA. The CEDA or the adoption of CEDA, adoption of this convention, has played very significant role in the area of protecting the rights of women, and therefore, the Article 6 of this convention is very effective provision which says that state parties shall take all necessary actions including legislation to suppress all forms of traffic in women and exploitation of prostitution of women. CEDA has the provision which directly relates to the problem of the trafficking of women. In earlier provisions of international law, the indirect relation of the trafficking of women was there, but the Article 6 of CEDA is the first provision of international law which directly deals with the problem of the trafficking of women. If there is any incidence of immoral trafficking of women, the state parties or the nations, they are duty bound under Article 6 of CEDA, under Article 6 of this convention, that they should take the legislative actions, meaning thereby that they should enact the laws, they should take other administrative initiatives or the measures for the purpose of suppressing, all forms of traffic in women. If this trafficking is made for any purpose, either it is made for sexual exploitation, or it is made for forced labor, or it is made for the transfer of organs, or it is made for any other purpose, all forms of human trafficking should be prohibited by the national legislations for the initiatives on the part of state parties to this convention. This is the mandate given by Article 6 of CEDA. The protocol to prevent, suppress and punish trafficking in persons, especially women and children, 2000. The CEDA, we see that under CEDA, the first provision was made directly to deal with the problem of trafficking of women, and this protocol seems to be one international initiative or one international law which directly deals with the problem of the trafficking of women and children. This protocol has been adopted with an objective to deal with an objective to protect the women and the children from any kind of trafficking. See Article 2 of this protocol. Article 2 provides for statement of purpose of the protocol, what is the objective of the protocol and for what purpose the protocol has been adopted. See the objective of the protocol in accordance with the statement of purpose. The protocol, that is to prevent and combat trafficking in persons, especially women and children. This protocol has been adopted with an objective to prevent and combat the trafficking in persons, but especially women and children, to protect and assist the victims of such trafficking, This is not only to prohibit or to prevent the trafficking in persons, in women and children, but it also has the objective to protect and assist the victims of such trafficking. It means that protocol also deals with the rehabilitative initiatives for the victims of human trafficking with full respect of their human rights and to promote cooperation among states parties to meet these objectives. Then Article 5 imposes duty on state parties to criminalize trafficking in persons for purpose of exploitation, which shall include prostitution, sexual exploitation, forced labor, slavery, servitude or removal of organs. These may be the different regions, these may be the different purposes for which the trafficking of persons is made, for which the trafficking of children is made, for which the trafficking of women is made. So, if the trafficking of women and children is made for any of these purposes are if it is made for the purpose of prostitution, if it is made for the purpose of sexual exploitation, if it is made for the forced labor, if it is made for the slavery, for the purpose of slavery, if it is made for the purpose of servitude, if it is made for the purpose of removal of organs, then this is the duty of the state parties to criminalize trafficking in persons. So, the state parties are obliged to take the legislative initiatives on their part to deal with the human trafficking for any of these purposes, the trafficking of women for any of these purposes. After discussing the international law, what is the mandate of international law? What are the directives which have been issued by the international community or by international agreements, by international conventions, by the international protocols adopted by the different nations by their own agreement? Now, we are to see the constitutional mandate. These all the international initiatives, when these are to be implemented, these are to be applied, these are to be enforced or these are to be included in the national legislations, then it becomes very important for that nation who wish to include the international mandate in their legislations to see whether the constitution of that nation, where the constitution of that country permits such inclusion, permits such enforcement, permits such application. It becomes easy for the nations, for the state parties to include the international mandate if their constitution permit such inclusion, and therefore, what are the constitutional mandate? What is the constitutional mandate and what are the constitutional provisions and constitutional principles which are dealing with the problem of the women, the trafficking of women? It becomes important for us to see. See the constitutional mandate or the mandate of Indian Constitution in this regard. We always refer to Article 15 because Article 15 gives the opportunity or capability or it enables the state, the government to take the discriminatory initiatives to make the positive discrimination, to make the affirmative discrimination in favor of women and children. Because women and children are the most vulnerable section of the society. They are always subjudicated and therefore, the special protection is needed for the guarantee of their rights, for giving them the opportunity to avail their constitutional rights, and therefore, Article 15(3) of the Constitution permits the state to take the positive discriminatory initiatives for the purpose of the protection of the women's rights and the children's rights. And thus such provisions, if any positive discrimination is made for the purpose of the protection of rights of women and children, such initiative on the part of state cannot be held invalid because of Article 15(3). Then Article 23(1), traffic in human trafficking, traffic and human trafficking and the wagging and other similar forms, article or forced labor are to be prohibited by law. The Constitution of India directs the state, it gives the mandate to the state, it gives the authority to the state to make the law, to prohibit the human trafficking, to prohibit the begging, to prohibit the similar forms of forced labor, because the begging is a form of forced labor. It has also become the organized crime, and therefore, the constitution gives the mandate to the state to make the initiative for prohibiting the human trafficking, for prohibiting the begging, for prohibiting the forced labor, for prohibiting any such forms of offences or any such forms of unethical or immoral activities by law. So, the Indian legislature is obliged, the Indian legislature is duty bound to make the law for the purpose to deal with, for the purpose to prohibit the human trafficking, for the purpose to prohibit any kind of begging, for the purpose to prohibit the any kind of forced labor. Human trafficking, for the purpose of prohibiting the human trafficking, it is the constitutional mandate to the Indian legislature to make the law, and any contravention to this provision shall be an offence punishable in accordance with the law. Generally, any activity is not declared as offence or the crime by the constitutions of the country. The constitutions of the country are the basic or fundamental law of the land. It gives only the directions and it lays down the basic or fundamental principles according to which the nations are to be run or to be regulated. The system of the nations is to be regulated, but we can see the seriousness of the problem of human trafficking, the problem of begging, the problem of the forced labor, that Indian constitution makers, they declared such incidences as the crime, as the offence, and the direction has been given to the legislature to make the law for prohibiting them and declaring them as an offence. Then Article 24. Article 24 our constitution says that no child below the age of 14 years should be employed or engaged in any hazardous employment. This is also one important reason for which the trafficking of the children is made, to employ them in the hazardous employments. Article 24 makes the provision, constitutional provision, gives the mandate to the Indian legislature to make the law to protect the children from any such kind of employment in hazardous activities. Article 39F, which is the part of directive principles of state policy. This directive principle of state policy was added by 42nd Amendment 1976, which says that state should ensure protection of dignity of children for better childhood, for better youth. The state should ensure the protection of dignity of the children, and the protection of dignity of the children can be maintained, can be protected only by protecting the children from such kind of immoral trafficking. The immoral trafficking is the greatest blot on the dignity of the children, and therefore, Article 39F also gives the direction to the state parties, to the Indian legislature to take the initiative for protecting the children from the human trafficking or for maintaining their dignity. Then Article 51E. Article 51E is very important provision in this regard. Article 51A, Article 51AE, Article 51A is the part 4 of Indian Constitution, and it provides for the fundamental duties for the citizens of this country. The certain duties have been laid down by Article 51A, and every citizen of India is obliged or duty bound to act in accordance with those duties or to perform those duties. Article 51AE lays down a particular fundamental duty to be practiced by the Indian citizens. What is this duty? The one important duty which has been imposed by way of Article 51AE is to renounce any such practices which are derogatory to the women. It is a duty of the citizens. So, both the legislatures, the government, are duty bound, are given direction or the mandate by the constitution. On the other hand, the social initiative should be taken on the part of the citizens of the country. The citizens of the country must also contribute to protect the women from any such immoral trafficking. If any such practice is there which is derogatory to the women, then certainly we are to denounce such a practice under Article 51 AE. Now, we are to see what are the national legislative actions or what are the legislative initiatives on the part of union legislature or on the part of state legislatures, particularly the union legislature in India. There was Indian Penal Code. Last year in the Indian legislature enacted the Bharatiya Nyaya Sanhita 2023, and this Bharatiya Nyaya Sanhita 2023 replaces Indian Penal Code. When we are talking about the provisions of Indian Penal Code, then certainly we are to see the provisions in the new law replacing Indian Penal Code, that is the Bharatiya Nyaya Sanhita. Therefore, I arranged the provisions of both the Indian Penal Code, the earlier provisions, and the provisions which are included by Bharatiya Nyaya Sanhita, the Indian Penal Code 1880 and Bharatiya Nyaya Sanhita 2023. What are the provisions to protect the women from human trafficking? See section 366A of IPC. 366A of IPC provided for imprisonment up to 10 years with fine for offence of inducing any minor girl below the age of 18 years to go to any place or to do any act that will incur girl to be forced or seduced to illicit intercourse with another person. This is one objective or the reason for which the trafficking in girls is made, to induce them to go to any other place and to force the girls for illicit intercourse. The international mandate, the constitutional mandate has been given effect in this provision of IPC, where the punishment up to 10 years with fine or offence for the offence of inducing any minor girl below the age of 18 years has been made the offence. This 366A is replaced by section 96 of Bharatiya Nyaya Sanhita, and this section 96 of Bharatiya Nyaya Sanhita punishes inducing any child to go to any place or to do any act that will to be forced for the or seduce to illicit intercourse with another person with imprisonment up to 10 years with fine. The punishment is similar, but the distinction has been made in the provision of 96 of Bharatiya Nyaya Sanhita. The term girl, minor girl, is replaced by the word child. So now both the girls and boys, they are protected from any such kind of trafficking. Section 66B of IPC, which is providing for imprisonment up to 10 years and fine for offence of importing any girl under the age of 18 years into India from any country or from state of Jammu and Kashmir with the intent or knowledge that she would be forced or seduced to illicit intercourse with another. That was the provision section 66B of IPC. If any importation of the girl child is made for the purpose of illicit intercourse, then it was punishable with the punishment up to 10 years and fine. Now, this section has been replaced by section 141 of BNS. A new inclusive and improved version of this provision has been placed in section 141 of BNS, Bharatiya Nyaya Sanhita, which provide for imprisonment up to 10 years and fine for offence of importing any girl under the age of 21 years or any boy below the age of 18 years into India from any country with the intent or knowledge that she or he would be forced for or seduced to illicit intercourse with another. So, the trafficking of or importation of any girl child or the importation of any male child is prohibited by Bharatiya Nyaya Samhita. Therefore, it is inclusive provision, and the importation earlier in 66A, 66B of IPC, we see that importation, the trafficking of any girl from Jammu Kashmir was also considered to be importation. It was arranged with the importation or the trafficking of any girl from any other country. But now the Jammu Kashmir is also the part of the territory of India in the similar way as other states, and Indian laws are applicable to Jammu and Kashmir also. Therefore, BNS 141 does not refer to state of Jammu and Kashmir, and it talks about only the importation of the girl child or the male child from any country. Section 370 of IPC and section 143 of Bharatiya Nyaya Samhita. There was section 370 in Indian Penal Code, and now it is replaced by 143 of Bharatiya Nyaya Samhita. This 143 of Bharatiya Nyaya Samhita penalizes trafficking of a person by threat, force, coercion, abduction, fraud, deception, abuse of power or inducement for exploitation, which includes any act of physical exploitation or any form of sexual exploitation, slavery or practices similar to slavery, servitude, beggary or forced removal of organs. So, for any of these purposes, the trafficking of a person is made. Trafficking of a person by threat, force, if any such trafficking is made by in this way or by for these purposes, it is punishable under section 143 of Bharatiya Nyaya Samhita. Now, see the table, the offence of trafficking and the prescribed punishment under Bharatiya Nyaya Samhita. Trafficking, rigorous imprisonment for 7 years to 10 years and fine. So, minimum 7 years imprisonment has been fixed. Trafficking of more than one person, rigorous imprisonment from 10 years to life imprisonment and fine. So, if any one person is trafficked, then the punishment is from 7 to 10 years, but if there is a trafficking of more than one person, then it becomes more serious crime, it becomes an organized crime, and therefore, this is punishable with the rigorous imprisonment from 10 years to the life imprisonment. Trafficking of a minor, if any minor child is trafficked, then it is punishable with the rigorous imprisonment from 10 years to life imprisonment. It is similar to the trafficking of more than one person. Trafficking of more than one minor, if the trafficking of more than one minor is made, then it is punishable with the rigorous imprisonment from 14 years to life imprisonment and fine. So, the punishment has been increased. If there is the trafficking of more than one child, this punishment is more than for the trafficking of more than one person or the trafficking of one minor. It is the minimum punishment is 14 years. Conviction of offence of trafficking of minor on more than one occasion. Trafficking of minor on more than one occasion. You see that the more stress has been given on the trafficking of minors. So, if one minor is trafficked, minimum punishment is 10 years and maximum is life imprisonment. When more than one minor is trafficked, minimum punishment becomes 14 years and maximum life imprisonment, fine including and fine also. But if the trafficking of minor is made more than once, then imprisonment for life, which shall mean imprisonment for remainder of natural life and fine. So, if more than one events or more than once the trafficking of minors is made, then the minimum punishment is the life imprisonment, and it will go throughout the life of the person, throughout the natural life of the person. Public servant or police officers involved in trafficking, if any public servant is involved or any police officer is involved in the trafficking, then the imprisonment for life, which shall mean imprisonment for remainder of natural life and fine. These are the provisions. Section 370A of IPC and section 144 of Bharatiya Nyaya Samhita provide punishment for exploitation of trafficking persons. If trafficked persons, if there is any exploitation of, that was the punishment for the offence of trafficking. But if the trafficked person is exploited, then if the person trafficked is a minor and been engaged in sexual exploitation, then the offender shall be punished with rigorous imprisonment for term not below 5 years up to 7 years and fine in IPC, and with rigorous imprisonment for term not below 5 years up to 10 years and fine in BNS. So, maximum, the limit of maximum punishment has been increased in Bharatiya Nyaya Samhita from 7 years in IPC to 10 years. If the person trafficked been engaged in sexual exploitation, if he is not minor, if he is the person, major person and he is engaged in sexual exploitation, then the offender shall be punished with the rigorous imprisonment of a term not below 3 years up to 5 years and fine, and rigorous imprisonment for term not below 3 years up to 7 years in the Bharatiya Nyaya Samhita. So, again we can see that here also the punishment has been increased in Bharatiya Nyaya Samhita. Section 372 of IPC and section 98 of BNS provide that selling of a child for the purpose of prostitution or illicit intercourse or any unlawful or immoral purpose intentionally or knowingly shall be punished with imprisonment up to 10 years and fine. Section 373 of IPC and section 99 of Bharatiya Nyaya Samhita provide that buying of a child for the purpose of prostitution, for illicit intercourse or any unlawful or immoral purpose intentionally or knowingly shall be punished with imprisonment up to 10 years and fine in IPC, and shall be punished with imprisonment from 7 years to 14 years and fine in BNS. Again the term of imprisonment has been increased in Bharatiya Nyaya Samhita. In IPC it was up to 10 years, the minimum punishment was not prescribed, but in Bharatiya Nyaya Samhita the minimum has been fixed as 7 years and maximum becomes 14 years. Then we come to the specific legislation which was made to protect the women from immoral traffic act, that is the Immoral Traffic Prevention Act 1956. This act was legislated on 30th December 1956 to prevent immoral trafficking. The preamble of the act provides that this act is to provide for the prevention of immoral traffic in pursuance to United Nations Convention on Suppression of Traffic in Persons and the Exploitation of Others, signed at New York on 9th day of May 1950. In 1950, this convention was agreed to, and in pursuance to this convention, the Immoral Traffic Prevention Act 1956 was enacted in India. Section 3 of Immoral Traffic Prevention Act provides for provision for punishing anyone who keeps or manages or acts or assists in keeping or management of brothel on first conviction with rigorous imprisonment for a term not less than 1 year up to 3 years and fine up to 2000 rupees. And in second or subsequent conviction, the rigorous imprisonment for a term not less than 2 years up to 5 years and minimum 2 years and maximum 5 years and fine up to rupees 2000. It may be submitted that the amount of fine may be increased. Section 4 provides that any person above the age of 18 years who knowingly lives on the earnings of the prostitution. So, any person who keeps brothel, who conduct the activity of prostitution, he is punishable under section 3, and section 4 punishes those persons who are above the 18 years and they knowingly live on the earnings of the prostitution. They knowingly use the earnings of the prostitution for their own purposes, or they live on the earnings of prostitution, they are punishable under section 4. This punishment is up to 2 years and the fine of 1000 rupees. Again, this punishment may also be increased. The minimum has not been fixed and the fine, the amount of fine also seems to be very less. Section 5 punishes procuring, inducing or trafficking persons for the sake of prostitution with punishment of rigorous imprisonment for the term 3 years to 7 years. Here the minimum has been fixed as 3 years and maximum 4 years. If any person procures, induces or takes any person for the sake of prostitution for the purpose of prostitution. Section 6 punishes detaining a person in premises where prostitution is carried on with or without consent, with imprisonment of either term which shall not be less than 7 years, but may extend to 10 years. This is from 7 to 10 years. It is important in this provision that if a person is detained, any other person in the premises where prostitution is carried on, then this detention of the person has been done with the consent of that person or without the consent of that person does not matter. Any individual, any person who detains any other person in the premises where the prostitution is carried on will be punishable irrespective of the consent of the person detained. Then provision of Child Marriage Act 2006, it is also important in this context because it also amounts to be the trafficking if any minor is married. The preamble of the act provides for the provision of solemnization of child marriages and for all the related matters. Section 12 prescribes the scenarios when marriage of a minor shall be null and void. And in this event we see that when child is sold or for marriage or trafficked or used for immoral purposes, this is one ground that the child is sold for marriage or trafficked or used for immoral purposes, and therefore this enactment is also relevant for the protection of women from immoral trafficking, because if any marriage is solemnized by way of trafficking of the girl child, then will become void. Now see the judicial approach. What is the approach of the Indian judiciary in this regard? There was a case which was decided in 1982, that is People's Union for Democratic Rights versus Union of India. This was the public interest litigation. The Supreme Court of India laid down the definition of forced labor as whenever anyone works or forced to work or labor below the minimum wage prescribed by the state, either because of physical force or due to hunger and necessity, it would be called forced labor as mentioned in Article 23 of Indian Constitution. So the forced labor was defined by the Supreme Court of India in the case of People's Union for Democratic Rights versus Union of India. And if any trafficking is made for the purpose of the forced labor, then it would be punishable. Lakshmikant Pandey versus Union of India 1984, the Supreme Court laid down guidelines for international adoption to keep control and check on trafficking through adoption. This is also one way out or one area for which, one purpose for which the trafficking is made. For international adoptions, the trafficking of children is made. MC Mehta versus State of Tamil Nadu 1996. In this, the Supreme Court laid down measures and guidance to support the victims of child labor and their family. Normally, the child labor is conducted by way of trafficking of the children. Then Geeta Kancha Tamang versus State of Maharashtra, court held that sealing and closing of brothels will be a step forward to tackle the issue of organized crime such as trafficking. This is very important decision of the Supreme Court of India in the case of Geeta Kancha, when the Supreme Court approved the initiatives on the part of the state to seal and to close the brothels. Supreme Court says that the sealing and closing of brothels will be a step forward to tackle the issue of organized crime such as trafficking. It means the Supreme Court of India has also recognized the trafficking as an organized crime, and this organized crime must be combated, must be eradicated by the state initiatives, by such as the closing of the brothels, such as the sealing of the brothels, So, this is all about the law relating to the protection of women from immoral traffic. Thank you very much.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you a very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance, they should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.